Someone make it make sense.
Probably a couple.
Hello, squirrel friends of the world. We are here with the latest out of Ada County. I always refresh this, and actually at the end of the last live stream, which was for Sarah Boone, I thought, I haven't refreshed the Idaho cases of interest page yet today, so let me check that. Sure enough, we have a slew of new court filings. I believe it's 16 to be exact, and this is still relating to the initial defense motions to strike the death penalty and also to strike the different aggravating factors. Just so you guys know, I do have a playlist for every trial that I'm covering, including this trial, or pre-trial. And so if you have missed any of the previous coverage regarding all of these different death penalty motions, they are all in the playlist. I do include really specific timestamps. So the last thing that happened was we went over all of the state's replies to the defense's motions. So now, or rather, I guess the state's objections to the defense's motions. And we got some really big news that I haven't seen covered at all, believe it or not, which is that the state decided to drop one of the 5 aggravating factors. So the defense had made motions for each of those 5, a motion to strike each of those 5 aggravating factors, but the state dropped one of them. It happened to be the felony murder aggravator. So now instead of 5 aggravating factors for the death penalty, they've got 4. And remember, the burden for this, if indeed he is found guilty, the burden then when it comes to the sentencing is on the state, and the state has to prove beyond a reasonable doubt at least one of the 4 aggravating factors. It was 5, it's now 4. So as you can imagine, the fewer there are, the better that is for the defense. So that was a huge win for them that they dropped that. So now what we've got is the defense's reply to the state's objections. So that's what we're going to be going over today. Shout out to Iowa Backyard. That's all right. We just appreciate you being here. Love it. Also, shout out to Squeaky and Batcat. For anyone who isn't familiar, Iowa's Backyard has an incredible YouTube channel with lots of cute animals. Squeaky is a squirrel. Batcat is a cat. And yes, so please do check out their channel if you are not familiar. 24/7 high definition camera going on there with all of the woodland creatures and free friends and animals and weather and whatnot. So, alrighty, so let's jump right on in. You may notice all of these tabs. Yes, there they all are. I got them all ready to go. So we're going to start with the very first one. I just pulled these up in the order that they were filed, or rather, I guess, filed and then registered onto the docket. So first one here we have reply to state's objection to expert testimony from Eliza Cover. And so this is going to be one of the expert witnesses that we would be expecting to hear at the upcoming hearing on November 7th, where there will be our oral argument over these motions. And there's 2 expert witnesses that the defense intends to or wants to call, and the state is objecting to both of them. And so this is the reply to that objection. So the state's objection to Professor Cover's testimony is that it provides legal analysis and that it relies on what it believes is unreliable empirical evidence. As to the latter, generally, the court is capable of deciding what weight to give evidence and determine what the foundation is, not the state. They're citing some case law here. The state's other objection is puzzling. The state cites to decision relating to providing legal opinions from non-lawyers to judges and quotes the part of it relating to providing legal opinions to juries. This is what the opinion actually says. We've previously held that testimony containing conclusions of law by an expert witness is generally inadmissible. For example, in Ballard v. Kerr, we concluded that when an expert witness offers a legal conclusion, it invades the province of the court to determine the applicable law. Additionally, Idaho Rule of Evidence 702 only permits expert testimony if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. We respectfully conclude that while the factual materials stated in the report are helpful, the legal analysis of a non-lawyer expert witness is not. Assuming the prosecutor read this, it is hard to understand how they believe it supports their argument. Professor Cover is a law professor. If this court can rely on her legal writing, it ought to be capable of considering her testimony. That's it for the first one, guys. And we're on to the next objection here. So this is for the other expert witness. Let me just zoom in a little bit here. Okay, Barbara Wolf, MD. And I believe that what Barbara Wolf, and again, this was covered in the last live stream where we went over the state's objections, I believe her specialty is really on execution methods. And, as it comes to like cruel and unusual punishment and all that. And so that's why it's a doctor, right? So the state's objection is based on its objection to his motion as to the method of execution statutorily permitted in Idaho, which is in part that it is premature. So what the state had been arguing is that it's premature to determine this because he's not yet been convicted. However, it's not really that strong of an argument, in my opinion, because as we know, they have to prepare now for the event. If he's convicted, it's going to go into that bifurcated, unless they get their motion granted to have it trifurcated portion, where they have to be ready for the death penalty, right? So we all know this. And so the state is saying it's premature because we haven't gotten there yet, but the defense needs to be preparing for it. And the state knows that. Mr. Kohberger has replied to that argument and relies on that argument here as to why the court should permit Dr. Wolf to testify. So I think they're referencing there's one of their separate filings will address this. So, okay. It's going to make me click out of these every time it seems. All right. So next up, we've got reply to state's objection to defendant's motion regarding non-statutory aggravating evidence. In case anyone's wondering what non-statutory aggravating evidence is, that is victim impact statements for the most part. That's really what it is. So we've covered this at length. Basically, you've got your aggravating factors, your statutory aggravating factors. Again, like we said, there's 4, not 5 now. And then you've got your non-statutory aggravating evidence. And that, like I said, victim impact statements, like stuff like that. So, and the trouble is that, there's many different things that could be problematic, but, in other words, there's going to be emotional testimony, and then the jury would hear that before then deliberating and returning a sentence, right? So this is just reviewing what they had already asked for. The state concedes that the necessity of providing notice of non-statutory aggravators and Mr. Kohberger requests nothing additional at this time. The state, however, argues against its burden. Not only does it argue that it need not prove non-statutory aggravation beyond a reasonable doubt, it apparently has no burden as to these aggravators at all. So part of what they're arguing, again, it's like a 2-part argument. Part of what they're talking about here is the defense, one of their 2 arguments in regards to the non-statutory aggravating evidence is that they were arguing that the state needs to be able to prove that evidence beyond a reasonable doubt. Now, I don't know how far that's going to get them because, the rules of evidence don't apply. I mean, I don't agree with the fact that this is how it is, but this is how it is. The rules of evidence don't apply when it comes to the sentencing hearing or that second part of the trial. So like I said initially, they do have a burden when it comes to the statutory aggravating factors, but there is not a burden to prove anything when it comes to the non-statutory aggravating evidence, aka witness, victim impact statements, things like that. So, but the defense is pushing back. So to arrive here, the state puts enormous weight on this line from State v. Creech, quote, that section of the court's findings denominated 5 facts and arguments found in aggravation, although including circumstances not statutorily listed and not expressly found beyond a reasonable doubt is not error, end quote. So they're saying if it's not statutorily listed and not found beyond a reasonable doubt, it's not error. It's only when it's in the statute that that burden of beyond a reasonable doubt applies. Putting to the side the fact that when Creech was decided it was a judge, not a jury, making decisions in death cases, the word expressly does not do for the state what it thinks it does. At the time of Creech, judges had to prove written findings as to statutory aggravators when determining whether to impose death. Okay, I think what they're saying is that's different than having people testifying in person. Thus, expressly is simply in reference to what the court had put in its written findings. The court in Creech was not holding that non-statutory aggravators could be found without proof, much less without proof beyond a reasonable doubt. This court should so find. And Jay Logsden is the defense attorney who's responsible for doing a lot of these motions. He's also the infamous Magna Carta. That was him as well. So, okay, we're on to the next one, guys. These are pretty short so far. All right, so reply to state's objection to defendant's motion to strike state's notice of intent to seek death penalty on grounds of contemporary standards of decency. The state argues that the Idaho Supreme Court previously determined that contemporary standards of decency do not preclude the death penalty. The court in Abdullah ruled against this challenge, finding that to launch such a challenge, a defendant needs to show changes in legislation or executive action to go along with changes in public opinion. So part of what this was about, just to kind of do a little brief overview, this was kind of arguing the motion, right, the defense's original motion, that, right, standards of contemporary decency, right? So this is basically public opinion that, most, people these days don't support the death penalty. Many states aren't using it anymore, things of that nature. And that, opinions have changed throughout, the world, and very few countries even use it, things like that. So that's why I brought that up, because here it says changes in public opinion. At that time, the court found that, quote, 32 states, the military, and the federal government continue to allow the death penalty as an option, end quote. And then they gave a cite, the state did, with that data. But it's from 2015, I will note. It's from 2015. That may have been true, but times have changed. Keep reading, Chelsea. Now, 24 states have an operating death penalty. So 24 versus 32 in 2015. So since 2015, 8 states have since discontinued the use of the death penalty. The federal government has declared a hold on executions. So again, that's pushing back on this where it says the federal government still uses it. Ohio's governor has paused executions until a new method is adopted, and Arizona has paused them until they can trust their courts to do the right thing. Therefore, in reality, less than half the states still have the death penalty pursuant to legislative or executive actions. Taking population of those states into account, support for the death penalty is even bleaker. Of those that do retain, so of those that just still, the states that do retain it still, death penalty: Idaho, Indiana, Kansas, Kentucky, Louisiana, Montana, Nevada, North Carolina, shameful, and Wyoming have not executed anyone in at least 10 years. Now, that is good news, but I hate that North Carolina is still among the ones that would possibly use it. And this is from the Death Penalty Information Center. Now, note, the state had cited information from the Death Penalty Information Center from, they cited the United States Department of Justice, but from 2015. No, sorry, let me back that up. They cited the Death Penalty Information Center from 2015. But the defense is coming in and citing the Death Penalty Information Center from, guess what, 2024. So I think that's a pretty strong argument. That leaves 13 jurisdictions with active death rows. Thus, the evolving standards of society and the unusualness of the death penalty have changed. This court should take these changes into account and strike the death penalty, or strike the penalty in this matter. All right. Another one bites the dust. Now we are on to states, or reply to state's objection to defendant's motion to strike future dangerousness aggravator. So now we are on to the aggravators. These are the statutory aggravators I've talked a lot about. So this is one of the 4 that remain, right? One of the 4. So just to make it really clear, one of the 4 statutory aggravating factors for the death penalty in this case is the future dangerousness. So the defense, or sorry, the defense made a motion to strike it. The state objected. This is the defense's reply. First, Mr. Kohberger would note that it appears the parties agree to call this the future dangerousness aggravator instead of the propensity aggravator. The first agreement Mr. Kohberger made was that Idaho's future dangerousness aggravator fails to narrow the class of individuals facing the death penalty. So we've talked a lot about this, but just briefly, for anyone who hasn't seen the other live streams covering these death penalty motions, narrowing the class is a big part of this, because the case law that has been cited on actually both sides here uses languaging to the extent of, like, quote, the worst of the worst, end quote. So it's a narrowing, right? Because, for example, you've got however many people, right, in any state, or all states combined, whatever. You've got people that are convicted, let's say, of first-degree murder, right? The worst, the highest possible, offense, the capital offense, that's the worst of the worst, first-degree murder. So for when the death penalty is an option, you then have to narrow it down, right? Out of that many people, how do you decide who lives and who dies? So it's really quite an arbitrary and subjective thing, right? Which is, that's a whole thing. So failure to narrow the class is part of what they talk about quite a bit in these documents, that and part of it is because it is arbitrary. But let's see what they say here, if they have any additional supporting argument. The state does not attempt to grapple with the myriad problems exposed by Mr. Kohberger's argument that Creech provides a meaningless gloss that merely describes murders as opposed to those who commit manslaughter. Instead, it oddly enough simply quotes the passage from Creech that undeniably describes manslaughter. Interesting. So here, it cannot be asserted that the propensity circumstance could conceivably be applied to every murder coming before a court in the state. We would construe propensity to exclude, for example, a person has no inclination to kill, but in an episode of rage, such as during an emotional family or lover's quarrel, and commits the offense of murder. We would doubt that most of those convicted of murder would again commit murder, and rather we construe that the propensity language to specify that person who is a willing, predisposed killer, a killer who tends toward destroying the life of another, one who kills with less than a normal amount of provocation. Or sorry, they would tends to destroying less they kill. Okay, what they're saying is one who kills with less than normal amount of provocation. That's making a distinction between manslaughter and like first degree murder. Yeah. We would hold that propensity assumes a proclivity, a susceptibility, and even an affinity toward committing the act of murder. Now, one thing I will note, right, is like this future dangerousness, as I said in the last live stream, this is a problem for me that this is a death penalty aggravator, because the thing is this. Future dangerousness is like, that's the whole thing, like protecting society, right? Which is one of the considerations when it comes to sentencing for any crime, regardless of what it is. One of those considerations is protecting the public, right? There's a number of factors. There's like punishment, right? But protecting the public. So when it comes to that, right? If you're dealing with a first degree murder where the options are either life without parole or the death penalty, how does the death penalty then, I ask, protect the public any more than life without parole, right? I mean, this to me doesn't really make sense from that standpoint. But another factor here that I think about is that what's really unique about this case when it comes to Bryan Kohberger, if in fact he is found guilty, is that he has no criminal history. And so where I could see future dangerousness being applicable, in my opinion, when it comes to sentencing, is if you've got a serial killer, someone who's killed time and time again, right? And typically if that's been the case, they've gone undetected. Like a lot of these serial killers where the cases have gone cold, right? It's more unusual for that to happen right now. It's just harder, it's easier to get caught after the first one. So then you wouldn't know if they would have become a serial killer, right? But if indeed, let's take, for example, the Long Island, serial killer list, Rex Heuermann, right? If indeed he is found guilty, that's someone who's got, one after another, more and more charges arising for serial killing, essentially, right? I don't even remember how many they've got now, but it's 4 or 5, something like that. But there's plenty of examples, right? Where it's like they kill a person and then there's time in between and then they kill again. And so, but if it takes a while to get caught, and by the time they've been caught, they've murdered many different people on different occasions over a decade or however long, I think that you can look at that as to support that they would be a danger in the future, right? It's like reoffending. However, even if that's the case, it still doesn't make them it doesn't make the public any more safe to kill them versus giving them life in prison without the possibility of parole, right? If they're in prison without the possibility of parole, they're not getting out. They're not a danger to the public. Okay. So I just wanted to make sure that was clear. So that's what makes this aggravator very, I don't know. I don't get it. I don't get it. Again, I see it. It makes more sense to me if it's like determining life without parole or life with parole or possibility of parole. Then it makes sense, right? To look at, okay, what's the possibility that they might reoffend? That makes sense to protect the public. But when he's never getting out of prison anyway, if he's convicted, I don't see the point. Okay. So what the Idaho Supreme Court of 1983 did not grasp is that it was describing first degree murder as opposed to voluntary manslaughter. The state repeats this mistake rather than grappling with it, understandably, because to do so would be to admit that Idaho's scheme fails utterly to define those who should be death eligible. That's, again, that failure to narrow the class. The state's real argument is that this court cannot overrule the mistakes of the Idaho Supreme Court. This court cannot, but it can refuse to perpetuate them. So one of the other arguments that the state made in pretty much every single one of their objections was they were like, here's some Idaho Supreme Court case law. This court, as in right now, it's Judge Hippler, right? This court, Judge Hippler in Ada County. One of their things that was like in every single objection was you can't overrule the Idaho Supreme Court. And they're right to the extent, I mean, it is binding case law for them, right? For Judge Hippler as the trial court. So what they're saying is like that you can't overrule. They're saying we agree you can't overrule them. And I love how they don't say like the decision or whatever, the mistakes they say. Oh, you can't overrule the mistakes, but it can refuse to perpetuate them. Okay. Next, Mr. Kohberger argues that this aggravator provides the jury with no guidance. The state now makes a meandering response that seems to attempt to refute the holding of Ford v. Wainwright, but then just restates it. The state does not try to provide a clear way of deciding when evidence of mental illness should be aggravating and when it should be mitigating. Now, that was another really interesting thing. I pointed this out too, where when it comes to like mental illness, for example, as a way to narrow whether it should be aggravating or mitigating, in their original motion to strike this aggravating factor, the defense pointed out very astutely that it used to be in times of past that mental illness was considered to be a mitigating factor. And as we know, it doesn't mean you get off scot-free. It doesn't mean you get less time. It means you just go to you go to a institution for, the criminally insane, essentially is what it boils down to, where you're able to have access to other potential treatment, or really it's going to boil down to medication that wouldn't be available in a regular facility. But still, it is considered, which is why it's weird that was considered a mitigating factor, because really it's not like they're getting any less harsh of a sentence. But anyway, but that was, in other words, right? Not guilty, for reasons of insanity, right? So like that insanity defense, it's considered a defense. But again, the interesting thing is like, if they plead not guilty due to insanity, it's like, well, that doesn't mean you just don't get, you still have to serve the sentence. You just serve it elsewhere. So, but yes, it has been considered a mitigating factor, right? That people use. They could be because they use it as a affirmative defense. Okay. But then what they argued was like, it can't be both a mitigating and aggravating factor at the same time, because it is also used to show that someone is more likely to offend again if they have mental illness. Okay, so Mr. Kohberger provides this court with a solution to this issue. Mr. Kohberger argues that future dangerousness cannot be a statutory aggravator. Aggravators are intended for deciding which first-degree murders merit the death penalty. Future dangerousness does not do that. It focuses on the person, not the act. As Mr. Kohberger notes, a jury can consider possible dangerousness, but only after Mr. Kohberger has been selected for the possibility of death. Okay, so what this is saying, I think they're taking issue with what the actual statute, because this is a statutory aggravator, says about future dangerousness. I'm sure we've covered that in one of the other live streams. We went over them, but it focuses on the person, not the act. And so what they're saying is that, hey, we're not saying that the jury can't consider it. We're saying the jury can consider it, but only after he's already been, when this says selected for the possibility of death, I would imagine this means convicted, and if still found eligible, as in these motions are denied. The state's response is that this court should not worry. After all, judges consider future dangerousness all the time. That is true. It is a typical consideration at sentencing, as I've noted. But the aggravators are not just factors for sentencing. These are intended to narrow those eligible. I see, right. So they're saying, okay, so the narrowing has to be done first, and then you have factors for sentencing. So I actually think this is a good argument that you can't switch the order. First, you have to narrow the class, and then you decide if it's a factor for sentencing. And they're saying, we agree, this aggravator can be a factor for sentencing, but it's being used to narrow the class, right? See, that's why this is in italics. Crime they have committed. This means they've already been found guilty, right? Convicted. So these are intended to narrow those eligible for the death penalty based on the crime they have committed. So after they've been found guilty, if they are, then you need to narrow. Then you can start narrowing the class and then determining the sentence. So I think that's what they're trying to say here. And that is something this aggravator does not do. All right. I'm really looking forward to the oral argument on this on November 7th. Okay, so next up, we have reply to state's objection to defendant's typo here. Wow. Motion to strike the death penalty on grounds of state speedy trial preventing effective assistance of counsel. So this was a funny one. So what they did, so we've jumped from one of the aggravating factors. Now we're back to just striking the death penalty altogether, right? So there's like two things going on. There's like all these different motions to just strike the death penalty, all of it. Then there's also the different motions to strike certain aggravating factors. Now we're back to a motion or a reply to the state's objection to the defense's motion to strike the death penalty altogether. And this was on the grounds of the speedy trial, that the state prevented speedy trial. Okay. Interestingly, the state impliedly concedes that having to choose between two constitutional rights would violate the Constitution by focusing its entire brief on what the Idaho Constitution guarantees a defendant by way of a speedy trial. The state denies that the Idaho Constitution guarantees a particular time frame for a trial, right? I remember that. Relying on cases from the Idaho Supreme Court that Mr. Kohberger argued must be overruled. Interesting. So some of this is going to come down to the different case law, supporting case law by either side. And that happens because, the way it works with case law is, you've got your case law, your opinion, but opinions get overturned all the time. And sometimes they may not be overturned. They just get flagged for being at risk of being overturned. So when you're looking at your different databases, like for example, Westlaw, and you're looking at case law, there's a rating and it's 5 different colors. I think it's green, yellow, orange, light red, dark red, or something like that. And it's showing you it's giving you a way to note what the reliability of that opinion is, right? So if it's green, it's been relied on, it's been, it's been approved, it's good to go, it's good case law to use. Yellow means maybe they're looking at it, right? And then when you get into the red color, that's it either is about to be overturned or it has been overturned. Same thing if there's been for example, on appeals, right? Where there's an appeal and then whatever it was, and we know this is kind of rare, right? With appeals, but something was successful and then it's remanded back to the trial court, then that would make that appellate opinion, it would make that original trial court opinion or decision not very reliable if the appellate court found it needed to be remanded back to the trial court, for example, for a new trial or for a decision on something else. The state provides no authority that supports these cases. It merely insists that they are the authority and must be followed. This is unsurprising, as these cases lack the sort of analysis typically seen in cases considering what the Constitution meant when it was ratified. They cite some case law without any argument as to what the Idaho Constitution speedy trial right meant to the framers. Shout out to the framers. The state's objection provides little for Mr. Kohberger to respond to. He asks this court to analyze the Idaho Constitution's guarantee and recognize that the framers expected better than the Barker factors to protect citizens from the government. All right. Another one done, guys. Woo! We will be, anyone who's watching these, this coverage with going over all these documents, we've covered every single document. Well, actually, since I started covering this trial, we've covered every single document. But that includes all of these documents related to the death penalty, and there's been a lot. And so this will make sure for anyone who's watching, again, there's a playlist, but we will all be up to speed when this hearing for oral argument happens on November 7th. Okay. Reply to state's objection to defendant's motion to strike the hack aggravator. So now we're back to another aggravator. This is the second of the 4 in terms of this defense's reply. And hack is the heinous, atrocious, or cruel. Of all of the aggravators, this one is perhaps the most upsetting. I have talked about it to a great extent on the other live streams where this has gone back and forth. Let's see what else they have to add here about this. The state argues that the hack in Idaho is constitutional based on the judicial gloss from Osborne. The state argues that Verska versus St. Alphonsus Regional Medical Center does not change the Idaho Supreme Court's ability to change the law. Mr. Kohberger does not know exactly what the state's authority is for this conclusion. The state appears to be comparing the idea of rewriting unambiguous laws with limiting constructions and finding a difference. And they cite the state's brief at 4. What the difference is not defined, or what that difference is not defined. The state does not argue that the hack is ambiguous. If the state agrees that it is ambiguous, the state provides no case that permits the Idaho Supreme Court to rewrite the statute to clarify it. Okay, that's interesting. All right, the larger issue that the United States Supreme Court suddenly created the power to rewrite statutory language to preserve the death penalty goes essentially unanalyzed in the state's objection. Again, even if this court cannot overrule the Idaho Supreme Court, it can acknowledge where its holdings violate the principles of law upon which our system was founded. The state then takes up the differences between ICJI, that's the Idaho Criminal Jury Instructions. And we went over that because in the jury instructions, it's, to me, okay, if anything is heinous, atrocious, and cruel to me, the jury instructions, the Idaho jury instructions for this aggravator meets that standard, if you can even find that standard. By the way, it defines heinous, atrocious, and cruel. Y'all check out the last live stream if you want to see that languaging specifically. It's very upsetting, at least to me. Completely subjective, redundant. It's a mess, in my opinion. Okay, between the ICJI and again, well, sorry, just to note. So the jury instructions, of course, is what is going to go back with the jury when they're deciding whether or not to agree with the death penalty. They're going to be given these, in my opinion, just completely lunatic definitions of what heinous, atrocious, and cruel mean. And it's just, yeah, it's a lot. All right, the ICJI and Osborne, and notes that they match. Counsel for Mr. Kohberger admits that in May of this year, the ICJI was amended to reflect the language of that opinion. However, that merely reinforces his original argument that this aggravator was not written by the legislature, but rather the Idaho Supreme Court. Interesting. Okay, Mr. Kohberger cannot be put to death on the grounds of an aggravator that was not adopted by the legislature. Interesting. Okay, well, I mean, if that's, I mean, that seems like a strong argument there. The difference is case law versus legislation, right? So let me explain why this is important, because, you know, we know that courts follow case law all the time, or they don't follow case law, you know, case law here, case law there, blah, blah, right? Remember, when it comes to something that's statutory, that means it comes from a statute, right? These are statutory aggravators. A statute has to be written from the legislature. So that's the difference, right? And the thing about case law is case law really is important in determining what courts should do when there isn't a statute for it, because as we know, that takes for fucking ever. And so if something has not been, you know, committed in writing by the legislature, has become a statute, then that's where the case law fills in those gaps, because, you know, there's so many different circumstances and facts of the case, and, you know, that the legislature can't possibly provide statutes for every single circumstance, right? But that's why if something is statutory, it's a big deal. It is saying that you have to follow the statute, and that is something that has to be done by the legislature, not case law. So that's what they're saying here. They're making that distinction. Okay, next up. Okay. Now we're back to another motion to strike the death penalty entirely, right? We went to another aggravator. Now we're back to the motion to strike the death penalty. So this is on the grounds of international law. So this is the defense's reply to the state's objection. This had a lot to do with like the international treaties, things of that nature. The state argues that the language of the International Covenant on Civil and Political Rights does not prohibit capital punishment. The ICCPR, ratified in 1966, is the only first instrument in a series addressing this matter. The second optional protocol, signed 20 years later, specifically aims at the abolition of the death penalty, declaring, quote, that abolition of the death penalty contributes to enhancement of human dignity and progressive development of human rights, end quote. The protocol specifically provides that, quote, no one within the jurisdiction of a state party to the present protocol shall be executed, end quote. The series of instruments make clear that the international community and international law has evolved and that the death penalty violates the mores, I guess it should be probably morals, and standards accepted of modern society. Also, they used the wrong accepted. This should be ACC EPT, wrong version of accepted. The state asserts that Idaho courts are not bound by the ICCPR because it was ratified subject to a reservation on the issue of capital punishment. The state notes that when the Senate ratified the ICCPR, it reserved the right to impose capital punishment subject to its constitutional constraints. In the very next subsection, the Senate states, quote, the United States considers itself bound by Article 7 to the extent that, quote, cruel, inhuman, or degrading treatment or punishment, end quote, means the cruel, unusual treatment or punishment prohibited by the 5th, 8th, and or 14th Amendments to the Constitution of the United States. Because of the improprieties of the capital sentencing process, the conditions under which the condemned are incarcerated, and the excessive delays between sentencing and execution under the Idaho death penalty system, the implementation of the death penalty in Idaho constitutes cruel, inhuman, or degrading treatment or punishment in violation of Article 7 of the ICCPR. When international human rights norms are applied, it is clear that Idaho's death penalty scheme violates international law. It violates the mores, he says mores again here, in standards accepted, again, but that's also spelled wrong, accepted of modern evolving society. Idaho's death penalty scheme on its face and as applied in Mr. Kohberger's case violates international treaties, including the ICCPR. Further, it is a clear violation of the fundamental, I think that's supposed to say precepts of international human rights. So this is normal, right? For any death penalty eligible case, you're going to have these motions to strike the death penalty. I don't know how successful those will be. I don't think they will be very successful personally, but I do think where there could be potentially more success is with striking the individual aggravating factors, because as we've seen already, the state dropped one of the 5. So I think there's potential there, but even if that doesn't go forward, their motion to trifurcate the proceedings, I think, is a really, really, really solid idea, solid motion. And I think that that's really how things should be done going forward for any death penalty case. And, the reason being that, in some states, the jury still decides on the sentencing, but it's very uncommon. I know we saw that in the Carly Gregg trial out of Mississippi, and, the jury voted on the sentence, but I don't think I've ever seen a trial, and I've just watched lots of trials. I don't think I've ever seen it ever done before, apart from that. Normally, the judge decides the sentencing unless it's a death penalty case. And then if it's a death penalty case, it always goes to the jury. So that is why, especially in death penalty cases, trifurcating the proceedings, I think, is just a no-brainer. So that would still be, I think that, again, you've got the biggest win for the defense would be striking the death penalty altogether. Don't think that's going to happen. The second biggest win for the defense would be striking any more of these other aggravating factors. I think there's potential there. And then the smallest win for the defense, but still a win, would be trifurcating the proceedings. Okay, so next up. And again, all of this is just with they're operating when it comes to these death penalty motions in the event that he's found guilty, right? Because again, they have to be ready to go right into this. So yeah. Okay. Reply to state's objection to defense amended motion to strike state's notice of intent to seek death. Okay. So this is another another motion to strike the death penalty altogether. This is on the grounds of means of execution. Now, what this one was dealing with was the fact that there's a lot of issues with being able to get the appropriate chemicals needed for the injection. And then, as we know, that's why Idaho has brought back the firing squad and all that. So part of this is about the fact that they don't know for sure how he would be executed because it's a mess. Again, I don't think this is going to go anywhere, but let's see what else they say. The state makes 3 arguments. 1, issues as to the matter of execution are not right. 2, that lethal injection is an improved method of killing in this country. And 3, so is the firing squad. As the state acknowledges any possible, so that's what the state argued, okay, in their objection. As the state acknowledges, any possible execution in this case is decades and decades away. Therefore, it is pointless to argue now over the propriety of how it might take place. And I will note, one of the main things that the state argued about when it came to the means of execution, when they were in their objections, one of the main things they kept saying is that it's not ripe for decision, as in this would be something that would happen closer to execution if he's found guilty and all that, and then he's the death penalty, right? This would be like, because of the fact that the methods of execution change so readily, and that executions, if someone's found guilty and is given the death penalty, decades away, right? Who knows what those methods will be decades in the future. So the state argued that repeatedly in their objections, that it's too early to be quibbling over, the method, right? That's what they said. So they're just reiterating what the state had said. Mr. Kohberger counters that if the delay and uncertainties about any eventual execution was a reason not to litigate such issues, then much of the case law requiring these issues to be raised in the trial court needs revisiting. Mr. Kohberger points out that millions of taxpayer dollars are being spent in this case because the state has decided to seek a penalty that will take so many decades to reach. Many of those involved in this matter will likely die of, I think they needed a separate sentence here and made a mistake. Let me read this again. I'll correct it. Mr. Kohberger points out that millions of taxpayer dollars are being spent in this case because the state has decided to seek a penalty that will take so many decades to reach. Many of those involved in this matter will likely die of natural causes. There we go. Punctuation. The question for this court is, quote, is it constitutional to kill this person in the manner set out by law, end quote. And if it is not, that ought to be the end of things. The time and money being expended on the what, I think there should not be a here, on what the state implies is merely a hypothetical, would itself be an injustice. Unfortunately, the death penalty remains too real a possibility to be ignored. That being said, Mr. Kohberger also acknowledges that the general judicial approach to manner of execution claims is to consider them as an afterthought, as the state's cited authorities hold. Mr. Kohberger's argument, however, is a challenge to the propriety of permitting a death verdict in this case when the state has no real plan to carry it out. So what they're saying is if the state doesn't have a clear way of this is how it's going to happen, then they shouldn't be allowed to come to that verdict or offer that as an option to the jury. It ought to be clear that if Idaho tomorrow adopted quartering, oh boy, as its method of execution, they left out the word of, I am fixing it, no person should be forced to sit on death row awaiting a punishment that clearly would violate the Eighth Amendment. Tragically, the rulings of our Supreme Court have made that entirely unclear. Now, they're referring to the U.S. Supreme Court here. A majority of the court has severed the sentence of death from the execution, and interesting the word severed here, and treated method of execution as a sterile subject fit for Logomachy. I don't know what that is. Worse still, despite its promises that prisoners may challenge means of execution by presenting an alternative, its recent decisions show those premises were quite empty. I'm going to look up that word, Logomachy. I mean, because, the thing is, there's so many typos. It could be a typo or a misspelling, or it could be a real word. Let's see. It is actually a real word, and it means a dispute or argument about words or their meanings. So kind of to me sounds like a synonym for semantics. Okay, that would make sense. So in context, right? A treated method of execution as a sterile subject fit for logogamy. You could kind of interchange that with semantics, I think, here. Okay, worse still, despite its promises that prisoners may challenge means of execution by presenting an alternative, its recent decisions show that those promises were quite empty. So one of the things that they're mentioning here is that it came up in one of the other documents that the prisoners can challenge the means of execution and offer a alternative. These are for folks that are on death row, okay? But what they're saying is that though that was what they said, recent decisions show those were empty promises, that they couldn't offer an alternative, it sounds like, okay? Or they were denied an alternative. In the face of these decisions, Mr. Kohberger argues that a death verdict under these circumstances violates the Eighth Amendment. Oh my God. The Supreme Court has never ruled on this issue. In point of fact, it has yet to rule on a single lackey claim. Mr. Kohberger is not making a true lackey claim, as he has yet to spend decades on death row, as the state foretells. I think the lackey claim is the one about being able to offer an alternative method of execution. His argument is that when it is so foreseeable that the death penalty in a case is almost purely symbolic, Yeah, the Constitution refuses it because what it amounts to is a state of dehumanization that cannot be justified. And they're citing some case law. Now, they're citing case law. I'm just going to note they're citing dissenting opinion, which isn't the best. That means that these, when you've got Supreme Court, right, you've got people that the dissent means they're in the minority. So the case law held whatever the majority decided. So dissenting is like not your strongest argument. However, because it's the Supreme Court, that opinion still goes into the case law where you can still read why there was a dissent. So they've cited case law, but they've cited the dissenting opinions. In Trop v. Dulles, the court held that the Eighth Amendment did not permit the government to denaturalize its citizens, even for a crime for which death was a possible punishment. It held. We believe, as did Chief Judge Clark in the court below, that use of denationalization as a punishment. So what they're talking about is this is something I hadn't even thought about in a long time. So that it could have, I guess, used to be a punishment at some point up until 1958. That you could denaturalize its citizen, as in instead of killing people, you're saying you're no longer an American citizen, which is interesting. I don't know what they would have done. Do they ship you off to another country? Interesting premise. Okay, that the use of denationalization, as a punishment is barred by the Eighth Amendment. There may be involved no physical mistreatment, no primitive torture. There is instead the total destruction of the individual's status in organized society. It is a form of punishment more primitive than torture, for it destroys the individual, the political existence that was centuries in the development. The punishment strips the citizen of his status in the national and international political community. His very existence is at the sufferance of the country in which he happens to find himself. So they don't relocate you, they just leave you there? I don't understand. While any one country may accord him some rights, and presumably as long as he remained in this country, he would enjoy the limited rights of an alien. Oh, interesting. No country need do so because he is stateless. Furthermore, his enjoyment of even the so in other words, what they're saying is like when it comes to this denationalization, if you were to do that, right, they wouldn't even be considered an alien, because an alien would be like every person is a citizen of some country, right? This is interesting to think about, because it would make them a citizen of nowhere. Wild, like that concept. So therefore, they can't even really be considered an alien because they're stateless. Furthermore, his enjoyment of even the limited rights of an alien may be subject to termination at any time by reason of deportation. And where would you take them to, right? In short, the expatriate has lost the right to have rights. This punishment is offensive to cardinal principles for which the Constitution stands. It subjects the individual to a fate of ever-increasing fear and distress. He knows not what discriminations may be established against him, what proscriptions may be directed against him, and when and for what cause his existence in his native land may be terminated. He may be subject to banishment, a fate universally decried by civilized people. He is stateless, a condition deplored in the international community of democracies. It is no answer to suggest that all the disastrous consequences of this fate may not be brought to bear on a stateless person. The threat makes the punishment obnoxious. I'm going to keep reading this, and before, I just wanted to say, here's where I think they may be going with this, potentially. Is that this is an opinion that was held, okay? And what made me think of this is right here. That part of the reason why banished or stopped the use of denationalization is here. In short, the expatriate has lost the right to have rights. One of the arguments that the defense has previously made is that by killing someone, they lose the right to have rights. So I'm wondering if that's where they're going to go with this, and using this opinion to support that. It's one and the same. Whether you make someone, you say you're no longer a U.S. citizen, you're stateless, or you kill them, either way, they lose the right to have rights. And I think it's a pretty strong argument. Again, unfortunately, I don't think it's going to go anywhere, although I don't know, I feel like it should be considered. All right. This punishment is offensive to cardinal principles for which the Constitution stands. It subjects the individual to a fate of ever... Oh, wait. I already read that part. Okay, let me go to where I was. Here we go. The civilized nations of the world are in virtual unanimity that statelessness is not to be imposed as a punishment for crime. It is true that several countries prescribe expatriation in the event that their nationals engage in conduct in derogation of native allegiance. Even statutes of this sort are generally applicable primarily to naturalized citizens, but use of denationalization as punishment for crime is an entirely different matter. The United Nations survey of the nationality laws of 84 nations of the world reveals that only 2 countries, the Philippines and Turkey, impose denationalization as the penalty for desertion. In this country, the 8th Amendment forbids this to be done. Mr. Kohberger argues that a death verdict in this case is analogous. Let's see if was I right? Analogous to the fate of ever-increasing fear and distress described in Trop, to permit the state to seek one where the actual means of execution are illegitimate is too great a farce for the 8th Amendment. Thus, this court should consider the issue now. So far, I'm not right. Well, they're citing the fear of ever-increasing fear and distress, or fate of ever-increasing fear and distress. But let's see. The state's argument in favor of its execution regime is to claim that Wilkerson upheld firing squads by pointing at other cases in which it was discussed. However, it may have been construed, its text does not say what the state is arguing. Additionally, in Bayes, Glossop, and Bucklew, the court eschewed the concept of punishments being constitutional or unconstitutional, except when compared to some other punishment that does not superadd, such as with pain, disgrace, torture, etc. Thus, no means of execution is currently constitutional or unconstitutional compared to another. Until compared to another. The state recognizes this in its next argument and rightly claims that Mr. Kohberger did not proffer a way in which he would like to be killed, and it should it come to that. So that's nonsensical because, again, like I said, the state has been arguing this whole time. It's too early to decide. It's too early to be talking about the method, blah, blah. But then they went ahead and contradicted themselves and said, well, you're not already suggesting an alternative. And I think I'm pretty sure that I probably goated, you goat with a verb there, because I can't stand that type of shit. The hypocrisy. Mr. Kohberger did not because he is not making a means of execution claim like in those cases. He's arguing that the state of Idaho violates the Constitution where it threatens its citizens with its current death penalty regime that relies on means of execution that cannot be carried out without causing undue pain. That's where that Dr. Barbara Wolf, I think, is going to come in if she's allowed to testify at that hearing. Mr. Kohberger should not have to spend decades in courts trying to keep from being killed in some horrible fashion. The 8th Amendment does not allow it, and neither may this court. Okay. So they didn't actually go back to what I thought they would, which was the you lose the right to have rights, but they did make that argument in their original motion or their initial motion there. So, okay. Reply to state's objection to defendant's motion to strike multiple victims aggravator. All right, so now we're back to another death penalty aggravating factor. This is the multiple victims. This is the third out of the 4 in terms of covering these replies. Multiple victims. Now, this I don't think will happen because I think it's clear that if he's found guilty, that there's multiple victims. But let's see what they say. Mr. Kohberger has argued that Idaho's multiple victims aggravator is unconstitutional as it does not actually accomplish any narrowing except as a more specific form of the propensity aggravator. The state in its response ignores this argument, instead cherry-picking from Mr. Kohberger's briefing and setting up its own strawman arguments to knock down. This largely consists of reading some of the authorities Mr. Kohberger cited for particular propositions and then claiming he used them to stand for something else entirely. Mr. Kohberger indicated that in Texas, the presence of multiple victims was important for determining future dangerousness. The state claims that Mr. Kohberger had argued that the article is against the use of multiple victims as an aggravator. So they're saying that the state misconstrued their case law. Mr. Kohberger does not think what he's arguing is so nuanced as to completely escape the state's ability to refute it, but given that the state provides no response to what he has argued, he sees nothing he can reply to. Mr. Kohberger asks this court to strike the multiple victims aggravator as it merely doubles the propensity/future dangerousness aggravator, which he argues against on its own merits elsewhere. Now we're back to another motion to strike the death penalty entirely on the grounds of failure to present aggravators to a neutral fact finder. This one is not going to go anywhere. I'm not even going to bother reading. Honestly, what this came down to is them trying to argue that the neutral fact finder would be a grand jury and that they would need a grand jury to assess these aggravating factors and determine whether or not they are valid. It's not going to go anywhere. Now they are citing Greg. I wonder, is this, no, this can't be the same Greg, different Greg, not Carly Greg, who I just referenced earlier. Okay, we're not gonna bother with that one. Let's go on to the next one. Because and by the way, in terms of the previous filings regarding that neutral fact finder, we did cover the motion and the objection, but it's not going to go anywhere. Okay, reply to state's objection to defendant's motion to strike. Okay, now this is the last aggravator here, utter disregard. This is another one that just makes me crazy, just like the hack aggravator and the future dangerousness. Honestly, the only one that doesn't make me absolutely crazy is the multiple victims, because that's not subjective. Like, that's objective. The rest of these are nonsense to me. Okay, so the state's objection to Mr. Kohberger's argument that Idaho cannot rewrite a statute via glass consists of the same argument it made to Mr. Kohberger's objection to the hack. And Mr. Kohberger incorporates his response into that reply to the extent that it is the same. So they're saying there's a lot of overlap. And I agree, there is a lot of overlap. That's part of what they thought. That's part of their argument initially, was like, there's so much overlap. These are basically saying the same thing, which they are. And both of them are nonsensical. That's me saying that, not them. The state, however, goes on to argue that the gloss does not change what the legislature has intended by the aggravator. The argument is based on the literal words of the aggravator. Mr. Kohberger would point out that the literal words of the statute were so broad that the Idaho Supreme Court held that they were unconstitutional. Here we go. Well, for anyone who missed all the coverage of the hack and the languaging that I thought was just atrocious, we're going to see a little snippet of it here. However, inasmuch as a reasonable person could fairly characterize any murder, this goes back to the narrowing again, right? Okay, any murder at all, right? Any person could characterize it as heinous, atrocious, or cruel, which again has its own set of problems because of how subjective those words are. But anyway, even if you decide in your own mind, okay, I think I understand how I can define these words for myself, and any murder would potentially qualify, right? That's what they're saying, is that doesn't narrow it down, right? Narrow the class. So, however, inasmuch as a reasonable person could fairly characterize any murder as especially heinous, atrocious, or cruel, manifesting exceptional depravity, and as exhibiting an utter disregard for human life, it is equally apparent under Godfrey that this court must place a limiting construction on these statutory aggravating circumstances so as to avoid the possibility of their application in an unconstitutional manner. So what they're saying is they have to figure out a way to make it more objective and to narrow the class, because this could apply, because really you could find that this applies to any murder, right? So it changed the aggravator to save it. It took an ambiguous law and changed it. Mr. Kohberger's interpretation of the literal words of the statute derived from the statutes and decisions that made use of the words utter disregard throughout history. The ICJI, and again, that's the jury instructions, and the Supreme Court's gloss was simply a saving construction created by the court to stop itself from having to hold the aggravator unconstitutional, which it was and continues to be. This court must so find. Now we're back to another motion to strike on grounds of arbitrariness. And again, this is back to striking the death penalty altogether. We've already covered all four of the statutory aggravating factors. So we're back to just the death penalty as a whole. Okay. Mr. Kohberger has argued that the death penalty in Idaho is as arbitrary as it was when the United States Supreme Court struck it down in Furman, because its aggravators are so broad and numerous that all forms of murder can be noticed for death. The state responded that this is not true, relying on the ruling in, I don't know how to say that word, that's some U.S. Supreme Court case law there. Unfortunately for the state, that case does not stand for the proposition that a single aggravator narrows who is eligible for the death penalty, nor was it an issue that a state's aggravators taken as a whole make every murder death penalty eligible. The only case ever to reach the United States Supreme Court on this issue is Hidalgo v. Arizona, which disappointingly did not result in an authoritative opinion. However, the case did provide a concurring opinion by Justice Bryan, joined by Justice Ginsburg, explaining that if it could be shown that a state has adopted a scheme that would capture all first-degree murder, it fails to satisfy the narrowing requirement. The state, however, doubles down on its improper reading of that same case by claiming that State v. Hall supports its interpretation of the law. That case focuses on a single aggravator, not all of them, just as the initial case did, and is of no assistance to the state's point. state then attempts to weave Mr. Kohberger's arguments into one by claiming that State v. Harrison supports his argument. Mr. Kohberger had, of course, noted that the court in Harrison ruled incorrectly, in his view, that the geographical issues in Idaho, right, that was a whole thing, in Idaho as to seeking the death penalty created a constitutional issue. The state now relies on the case to argue that the Idaho Supreme Court has already ruled on the narrowing function in Idaho. However, the court's ruling in Harrison was, while we doubt Harrison's underlying assumption that Idaho provides no meaningful narrowing, we find no legal basis for the review of all Idaho first-degree murder cases that he suggests. Each aggravating circumstance must provide a principled basis for distinguishing between those who deserve the death penalty and those who do not. Again, the narrowing. And it has to use clear and objective standards. Again, this has all been cited before here. The court's ruling was on whether a court could still determine who deserved death, not on whether the statutory structure had failed the narrowing function. The case predates the requirement that juries determine punishment and predates Hidalgo, so the court could hardly be blamed for not recognizing what Harrison's attorneys were arguing. The issue, an issue thus far undecided in this state, is whether Idaho has failed to provide sufficient narrowing to prevent allowing juries to arbitrarily sentence people to death. Neither Harrison nor the state's brief provide any holding or argument regarding how Idaho's scheme accomplishes this task. The state then focuses on the states that have considered the argument and come up with a rather odd grouping of supporters. Hidalgo itself, followed by Delaware, which no longer has the death penalty, Virginia, which no longer has the death penalty, and Colorado, which no longer has the death penalty. And, you know, I pointed out at the time, actually reading the state's objection, I was like, wow, why are they citing so much case law from, like, they had a lot of Colorado case law, which was interesting because, yeah, Colorado doesn't have the death penalty, but also that's not binding on the court. So in essence, the state argues, look at these states that realize the death penalty is a gross injustice. Just before they did, they rejected this argument. The state's ostrich argument should be as unconvincing in Idaho as it is now in these states. The state's final and weakest argument is that the narrowing function in Idaho is fulfilled by letting a jury decide who lives and its rejection of the death penalty for the severely mentally ill. Now we're back to the mentally ill. Assuming the state intended this as a serious argument, this court need merely consider the cases previously cited that a blanket, no, quote, no severely mentally ill defendants, end quote, rule does not provide proper narrowing any more than, quote, kill whoever you wish, end quote, which was literally the problem articulated in Furman. So when this came up, this was about how they were, what was it? The state was trying to talk about how mental illness came in as like a narrowing thing, because in other words, you have to have, okay, like you can't actually, for those who qualify legally, right, for like insanity, right, that type of thing, which we know that's a really high bar. Those are folks who might not have been competent to stand trial. They also wouldn't even recognize what they're doing on death row, that type of thing. And they cannot execute people who don't understand what's happening, right? So the state, like you have to be competent and all that to be on death row and be executed. So, but what they're saying is that, and they had, there's been previous, you know, this has been in the previous motions, right, where they elaborate, but basically that technically, like when it comes to mental illness, one could argue that anyone who would kill another person has some type of mental illness, even if it's not like insanity, right? Because mental illness, this is just as it like mental illness when it comes to just like a diagnosis, right? Like so many people would qualify for some sort of mental illness or whatever, but that you could argue that someone who would kill another person in first-degree murder like automatically qualifies for that, right? So that's why they're saying that this argument from the state does not provide any proper narrowing than, quote, kill whoever you wish, or sorry, kill whomever you wish. That's a bold statement right there. Shout out to Jack Johnston. I don't know if I've seen you before here. If you're new, welcome. Happy to see you, my friend. Welcome to the Squirrel Crew. So yes, okay. Mr. Kohberger also argued that geography plays the greatest role in Idaho as to who gets the death penalty based on the work of Professor Cover. The state responded that Professor Cover did not make any such claim. The state relies on Professor Cover, acknowledging she cannot draw conclusions as to why the death penalty is sought in any particular place. Mr. Kohberger argues that what matters at a constitutional level is that the cases that receive a filing seeking death and the cases that receive the death penalty have no discernible qualitative difference from each other, but they can easily point to where they were filed. Interesting. A system that claims to be based on, quote, justice, end quote. Wow. should and must be better. Well, I definitely agree. Finally, the state attempts to assault Professor Cover's article. It attacks its foundations, claiming this court cannot know whether Professor Cover reviewed the right materials to reach a conclusion. It does so in what it claims are 3 different ways, but all boil down to the same complaint. The state's nitpicking is telling. Any rational being, wow, you can see Jay Logsden seems to be getting more and more angry with the state as each one of these goes along. Any rational being, we had justice in scare quotes now, any rational being could foresee upon reviewing Idaho's statutory scheme that it would be far too broad to not apply to every first-degree murder. I agree. It is frankly disappointing that our judiciary requires a study to make plain what everyone already knows. Wow. Oh, man. The state's argument is that if Sergeant Schultz in Hogan's Heroes, sorry, let me say this again. The state's argument is that of Sergeant Schultz in Hogan's Heroes screaming, "I see nothing," in the face of the obvious. Unfortunately, I don't know this reference at all. That's very interesting to bring up such like a, like, what's the right word? A very specific reference. Maybe he has knowledge that Judge Hippler likes this show. I have no idea what this is. Is this a cartoon? I have no idea. I don't know who Sergeant Schultz is. I don't know what this, maybe we'll look it up when I finish reading these documents. Mr. Kohberger hopes this court recognizes they left off the S. Mr. Kohberger hopes this court recognizes the validity of his challenge and strike down this unconstitutional scheme. I'll leave this up so I can see specifically the name of this character in case I decide to look that up. Okay, next up, 2 to go. Reply to state's objection to defendant's motion and memorandum in support of motion to, okay. All right, y'all, this is about trifurcating. I think this is really important. And again, for me, this would be maybe the smallest win of the defense's possible wins here, if any of them happen. But I think trifurcating is an absolute necessity and it should be happening 100%. I don't know why it's not already. I mean, I guess the answer to that would be that the courts are so slow to make changes. We all know that, but it's a shame, I think. The state objects to the idea of a trifurcated proceeding on the grounds that it is not contemplated by statute, difficult in practice, and objectionable in post-conviction proceedings. As to the statutory scheme, nothing in the statute prevents trifurcation. As it states in Idaho Rules of Evidence 611, it is important for a court to decide how evidence should be presented to arrive at the truth. I'm going to repeat that. As it states in Idaho Rules of Evidence 611, Rule 611, it is important for a court to decide how evidence should be presented to arrive at the truth. That's why there's rules, people. Mr. Kohberger argues that trifurcation would be helpful in that regard for the various reasons he has argued. As to how difficult it is to do, the difficulty, that's silly, state, come on. Mr. Kohberger's attorney, Mr. Logsden, was of counsel in Renfro and took part in the trifurcation in that case, which was not difficult. So Jay Logsden, who's the one writing this and now referring to himself in the third person, has actually taken part in a trifurcated proceeding. Whatever post-conviction counsel may think, which I'll just say that is great. That's awesome that he has experience in that and is, writing these motions. Whatever post-conviction counsel may think about how it was handled in that case, it was certainly not awkward or difficult to do, and the fact that various other jurisdictions Mr. Kohberger has already listed in his motion affirms that. Mr. Kohberger would note that the state's example of what may cause confusion, the propensity aggravator, is actually a good example. I knew where he was going with this. I thought this exact when he said Mr. Kohberger would note that the state's example of what may cause confusion, the propensity aggravator. I was like, I know exactly what they're going to say. It's an example of why it should be struck, and sure enough, is actually a good example of why that statutory aggravator ought to be struck entirely. It simply is not the sort of aggravator that should exist in the eligibility phase. The real problem this court has to grapple with is the hodgepodge, he says, death sentencing scheme Idaho has due to its transition from a judge as sentencer to jury as sentencer state. So they're talking about the jury determining the sentences, right, when it comes to the death penalty. And that's true, right? So it used to be, and I couldn't tell you in all states, which states and when. That would be a whole project, right? But there was a time, in Idaho at least, where the judge would also determine the sentence if it was a death penalty eligible case. And as we see, every state that has the death penalty still, it comes to the jury to make that decision, including Idaho. So that's what they're saying. Transitioning from a judge as sentencer to jury as sentencer state. It is one thing to throw all this information at a trained lawyer. And again, this has to do with the trifurcation matters because this really has to do with the victim impact statements for the most part. And what they're saying is like, and I've talked about this at length, but just in summary, when it comes, like, my opinion is that any trial, when it's, especially when it's a capital case that could result in a long sentence, like, I feel like they should all be bifurcated, and that if it's death penalty eligible, it should be trifurcated. Because I always think about this, right? You know, in so many cases that I've covered and others cover are first degree murder cases where LWOP, right? Or like a good example would be the Ezra McCandless trial, which we just covered recently. That was a good example of this because in that particular trial, in that case, the judge, okay, the sentences that she could have been given included like life without parole, which would mean like eligible for parole after like 20 years or something, eligible, right? Or eligible for parole after some other number of years, or life without parole, LWOP. So there's a huge range for her. That's not always the case in these trials, but particularly for her, that was what the judge was looking at, right? So it wasn't like something like in other cases where there's a mandatory minimum. It's going to be LWOP, right? We already know. So in that case, the sentencing was a very long proceeding, and they had victim impact statements, and they also had defense impact statements. So people that came in on behalf of the defendant, who was, well, now convicted, right, at that point, and talked about, so it was I've never really seen anything quite like that I can recall. It was very unique. And the whole time her attorney was arguing and it was wild. If anyone's interested in seeing that, go to the Ezra McCandless playlist. It's the very last episode because it's the sentencing. So it was very interesting. And so there was a lot of emotional testimony for hours. There was emotional testimony about the victim, and then there was emotional testimony from her family and friends and people she met in jail and whatnot. And it was very, very, very emotional. And in that case, though, because it was not a death penalty case, and Wisconsin doesn't have the death penalty anyway, but just to show the difference, right? The judge is the one listening to all of the victim impact statements and the defense impact statements and that emotional testimony, and is then going to determine a sentence. And so think about this with all these different cases, right? When we know the judge is going to be determining the sentence, and then you've got a lot of emotional testimony, you know, I always think to myself, like, how much is that going to sway their decision? Because really, it's like they should be relying on the law, you know, and looking at the past criminal background, if any, you know, all the different factors. There's so many. But sometimes you see the judges even start to try to, you know, hold back emotions, right? What they're saying here is that is still different. Like, even if a judge is being confronted or presented with a lot of emotional testimony that really shouldn't impact the sentence, really, right? That is still different than presenting that to a jury. And I agree. So they're saying to throw all this information at a trained lawyer, like a judge, right, and expect to get a well-reasoned decision, which they do, and quite another to do it to 12 citizens with no formal training. And so, but this is exactly why I feel like they should always be bifurcated, so that the judge determines the sentence based on the law. And then after the sentence has been decided, right, I'm speaking of in a non-death penalty case, like a LWOP case or whatever, that then after the sentence is rendered, then you can let the victim speak. And that way there's no constraints, there's no objections, there's no restrictions, and there's no risk that it would impact the sentence. But in a death penalty case, because it's already bifurcated, that's why it would be trifurcated if you were to follow that same model. The idea being that, I think, and I've talked about it again at length, but it's good for everybody, I believe, because that way the sentence is based, again, on the law and what is statutorily required. And also for the victims' families or the defendants' families, then they can talk without having to worry about, you know, again, like I said, constraints, restrictions, time limits, whatever the case may be. And again, if great example of that, the Ezra trial is a great example of that, because there were a lot of objections. And the defense took a lot of issues with the way For example, some of the victims' friends and family would talk directly to the the convicted at that point. And they were like, no, they have to address the court, things like that, right? To where it interrupts them. They can't just freely speak, and they should be able to do that. And that's part of it, right? We know that the victims have rights, and it is their right to speak and before the court and before the public. And that is, and I agree. And I feel like, for me, at least from what I've seen, their rights are also somewhat infringed when that has to happen before a sentence is rendered. So anyway, okay, I'll move on. Add to this that the case law itself on what aspects of the scheme should help the selection process as opposed to the sentencing process. And it can feel like too much to try to figure out on how to provide jurors with a logical and understandable system. However, that is the job that must be done. To get there, Mr. Kohberger has not only requested a trifurcated trial, he has also pointed out that each of the statutory aggravators in this case have crippling flaws. Assuming this court determines that any of them survive scrutiny, that a trifurcated proceeding is the only reasonable way to proceed. And that is literally what I said a while ago, right? That the biggest win for the defense, all the death penalty is struck. Second biggest win, some or more aggravators, are struck. But the smallest win, but it would still be a win, would be this. But I do agree that is the only reasonable way to proceed. I totally agree. Okay, we got one left, guys. Okay, and this is the longest one somehow. Amended motion to strike state's notice of intent to seek death on grounds of means of execution. So this is going to be going back to, again, it's come up in some of the other documents we've already read today about the means by which you would execute somebody. This motion is made on the grounds that upon a conviction and sentence of death, the process by which Mr. Kohberger will be put to death in Idaho violates. So is this, oh, okay, that's why it's so long. Okay, that's why it's so long. So I know what happened here. Okay, this is the same motion that they initially filed that we've covered. All they've done is they've amended it because initially it was the caption. The caption here initially was said, motion to strike state's notice of intent to seek death. And it was like on grounds of like vagueness and arbitrariness. They just wanted to change the caption. So they've amended it just to change the caption to grounds of means of execution. But the content of this is the same, because I remember this. And actually I did see there was another filing that showed that there was an order that it was granted to change the caption. And it explained what I just said about the caption. So that explains why this is the same. So we've already covered this. So this isn't anything new. This is just, they've just fixed the title. So, okay, then we've done it all. Now here, Hogan's Heroes. So does anybody know what that is? Let's see. Oh, it's from 1965. That's so funny because I kind of, when it said Sergeant, I don't know why, I had this feeling that it was either a cartoon or an older TV show. It's from 1965. It's a sitcom. It's supposed to be funny. It says, oh, wow. Okay. The description says, perhaps the funniest show ever made about fictional hilarity in a Nazi prisoner of war prison. Wow. Interesting. I wonder if it's supposed to be satirical. Anyway, Sergeant Schultz. Let's see if I can find him specifically. No, it doesn't even look like it's on here. Anyway, so there you have it. Hopefully Judge Hippler got this reference, right? Because otherwise it'd be kind of lost. But that's it. That's all of it. So as always, though, I will keep an eye out for any other new court filings. I don't think at this point the state's going to respond. I think that's for oral argument, slated for November the 7th. So, that's your standard, right? You've got a motion, you've got an objection, you've got a reply. And they're just gearing up for that hearing. But there could be court filings related to something else. You never know. At the very least, there should be a decision made on the witnesses, right? The expert witnesses. That will be made, because are they going to be able to testify or not? So it was the Eliza Cover and then Barbara Wolf, those two expert witnesses, to find out whether or not they will be able to testify at this hearing. So I will be on the lookout for a decision on that. But that is all we've got for today. So we are all up to speed. And tonight, guys, I will be finishing recaps from the Sarah Boone trial. This will be day 6, the last day. Tomorrow, we've got the next installment of the Casey Anthony trial series. Again, there's a playlist for all of these different cases, trials I'm covering. And then after that, the plan is for me to do, what I'm going to do is we're going to review the, because it wasn't played in court, the Bryan Boone interview with law enforcement. I don't know why it wasn't played in court, but it wasn't. We're going to review that. And then there's also the Sarah Boone's interrogation. It's been, there's an alternate angle that just recently came out where you can actually see all 3 people, like her and both detectives, the whole time. And that quality is a lot better. And it's very different seeing it from that other camera angle. So we might also go over that. And if there's any jurors that do speak out, we will cover that as well. And we might also cover some of the statements made by her attorney if we don't cover that tonight. Press conferences, things of that nature. So thanks, guys, for being here. And yes, correct. Thank you. Yes, we did. I did Google that. So you might have already typed that in and maybe I didn't see it. Yeah, a comedy classic. Okay. Have you actually seen the show? Do you know who Sergeant Schultz is? But yes, so appreciate y'all being here and stay tuned for up-to-date coverage of the latest out of Ada County. As I will say, it used to be Layton, now it's Ada. And thanks for being a squirrel. Love y'all. And I will see you on the next video.